esteemed Professor Subramanian, members of the faculty, and fellow students. I address you as fellow students in the fond hope that I am still a student and have not stopped learning. Judicial independence as a basic feature of the Constitution is the subject of today's session. Judicial independence, even without the basic structure doctrine, judicial independence, even without the basic structure doctrine, is and has always been of vital significance. It's a matter of great concern, and in a constitutional democracy with an entrenched Bill of Rights, the essence of the constitutional scheme is checks and balances. The agency constitutionally invested with the power to oversee and enforce these checks and balances is the judiciary. And that underscores the importance and the imperativeness of judicial independence. Now, independence of the judiciary is a great concept. It operates at different planes: philosophical, ethical, behavioral, functional, and therefore it is important and necessary for us to understand the concept, the content, the nuances, and also its limitations. Because it is not something that must be stretched too far. In an article in the Law Quarterly Review in 1977, Professor Joseph Rass, writing about the rule of law and its virtue, eloquently said, "Conformity to the rule of law is not an ultimate goal. After all, the rule of law is meant to enable the law to promote social good. Sacrificing too many social goals onto the rule of law may make the law empty and barren." Perhaps we could say this of judicial independence as well, because judicial independence is not an end in itself. The ultimate guarantee for upholding constitutional values and enforcing constitutional limitations and upholding the rule of law, the rights of the people, is the personality and intellectual integrity of the judges. Constitutional guarantees are futile unless they are enforced by judges of ability and integrity, who can withstand pressures from all quarters, within and without, including their own notions. This is extremely important. When we speak of judicial independence, ideally a judge must be independent of himself. A fearless and independent judiciary is the bedrock of a constitutional edifice. Democracy cannot exist without justice, and justice cannot be dispensed without an independent and fearless judiciary. The judiciary must possess and be seen to have fierce independence manifested through a rare courage of conviction. Lord Wolfe, the former Lord Chief Justice of England and Wales, perceptively put it: judicial independence is not the property of the judiciary, but a commodity to be held by the judiciary in trust for the public. This is what we must always remember. We must be clear as to what independence of judiciary really signifies. In its classical and generally understood notion, it embodies the idea that judiciary should be independent, that is free from executive control and pressure, and judges should decide cases that come before them, not according to the likes and dislikes of the government, but freely, fairly, and impartially. The United Nations concept of judicial independence, reflected in the 1975 Basic Principles on Independence of the Judiciary, is very comprehensive. The standard is the judiciary shall decide matters before them without restrictions, improper influences, inducements, pressures, threats, interferences, direct or indirect, from any quarter or for any reason. What does all this mean? What the Supreme Court said in 2010 in the first Madras Bar Association case perhaps reflects the idea in all its comprehensiveness. I quote, "Impartiality, independence, fairness and reasonableness in decision making are the hallmarks of the judiciary. If impartiality is the soul of the judiciary, independence is its lifeblood. Without independence, impartiality cannot thrive. Independence is not freedom for judges to do what they like." Please mark this, and this is what the Supreme Court, with respect, very rightly and pointedly said. Independence is not freedom for judges to do what they like. It is independence of judicial thought. It's freedom from interference and pressures, which provides the judicial atmosphere where a judge can work with absolute commitment to the cause of justice and constitutional values. It also means discipline in life, habits, and outlook that enable a judge to be impartial. Its existence depends not only on philosophical, ethical, or moral aspects, but also several mundane things like security in tenure, freedom from ordinary worries, and more importantly, freedom from influences and pressures within, that is from others in the judiciary, and without, from the executive. We speak of the court as though it were an abstraction. Sure enough, the court is an institution, but it is made up of men and women who, with their diversities of endowment, experience, attitude, and outlook, determine its actions and the course of its development. Durgadas Basu, in his celebrated Tagore Law Lectures, Limited Garment and Judicial Review, has this to say, talking of the personnel, because judicial review is a very important, it's the lifeblood of a democracy, but then judicial review is also, the power is exercised through human agency. It doesn't, those who exercise the power of judicial review do not fall from the heavens. They come from the earth. And this is what Basu says. It goes without saying that a court cannot claim to be respected unless its individual members command respect and confidence of the people. Independence does not mean merely security of tenure or decent salaries, but a condition under which judges may keep their oath to uphold the Constitution and the law. It is futile to expect an impartial judgment from a judge who is not immune from extraneous influences of whatever kind. Learned Hand said, an independent person would be a person whom nothing could daunt and nothing could blind. These qualities must also inform the court's functioning on the administrative side. It is inherent in the independence of judges that they should be seen to be independent of each other, observed Lord Bingham. Lord Bingham is perhaps the only law lord who has held all the three offices. He was Master of the Rolls, Lord Chief Justice of England and Wales, and the senior law lord presiding over the House of Lords, and considered perhaps the greatest law lord in the late 20th and the early 21st century in our own times. In a recent judgment, Somesh Chaurya versus State of Madhya Pradesh, Justice Dhananjay Chandrachud, as the learned Chief Justice then was, observed that independence of judiciary is independence of each and every judge. The judges are independent of their judicial superiors and colleagues. This is very important because whatever the theory, we know from experience how things happen many times. Independent of their judicial superiors and colleagues. There are various constitutional provisions which ensure independence of the judiciary. Article 50 is one of them, speaks of separation of judiciary from the executive. But we must remember that there is more fusion than separation between the legislature and the executive in our parliamentary system of government. Please go back to Justice Mukherjee's judgment in Ram Javaya, where you get an excellent delineation of the form of government that the Constitution envisages. But the judiciary is separate and has to be. It has to keep its distance. The relationship between the judiciary and the other wings, it is rightly said, has to be correct and proper, not cordial. Some struggle and tension is inevitable. Reciprocal influence is a continuing process. A great Canadian judge is Marshall, not Chief Justice John Marshall, writing about judicial independence a few decades ago, observed rightly that even unavoidable interactions between the top echelons of the judiciary and the executive can sometimes be harmful to judicial independence. And that's why we say the relationship must be correct. You meet wherever there is a necessity. You don't meet for bonfire. There is a recent trend, unfortunately, for judges of the Supreme Court and High Court speaking in very adulatory terms and lavishing fulsome praise on the head of the political executive, whether at the center or in the states. Such behavior and remarks can only be described as being in absolutely bad taste and totally unwarranted. This is not to cast any aspersions on the head of the political executive, who are elected leaders of the nation and are entitled to great respect. But institutional propriety would dictate that sitting judges do not indulge in such talk or behavior. Let me also tell you that even the body language says all that. When judges meet the Prime Minister or the President, even their silence is eloquent, and not eloquent in the right sense, eloquent for all the wrong reasons. Such statements by judges would shake public confidence in their independence and impartiality, tend to lower the dignity of the judiciary and constitute a threat to the rule of law. The ramparts, as Justice Khanna, H.R. Khanna always reminded us, do not fall except from within. Such statements and behavior are also not in consonance with the spirit of the Bangalore Principles about independence of judges and restatement of values of judicial life, which was adopted at the Conference of Chief Justices in 1998. Now, judicial independence is a variety of dimensions, not confined to independence from executive pressure or influence. That is just one aspect. It includes independence from and fearlessness of all power centers, economic, political, social. But above all, the judge has to be independent of himself. He cannot allow his private notions and predilections to be erected into constitutional principles. To be free of oneself, to uphold not that which one likes, but also what one hates, is of the very essence. In the memorable words of Justice Vivian Bose in State of Madras versus Krishnan, almost at the inception of the Constitution in 1951, I cannot allow personal predilections to sway my judgment of the Constitution. I don't think it could have been put better. Please remember, Vivian Bose is the master of purple prose. It has been rightly said, the highest, and this is what I'm quoting Justice Frankfurter, the highest exercise of judicial duty is to subordinate one's private personal pulls and private views to the law, of which we are all guardians, those impersonal convictions that make a society a civilized community and not the victims of personal rule. Judges are human beings, not disembodied spirits. Like the rest of us, they cannot completely shed their ideas and ideologies. It is inevitable that their so-called philosophy and scale of values play an important part in their decision-making, as Chief Justice Patanjali Shastri told us long ago in V.G. Rao's case. And Justice Cardoso, in his Nature of the Judicial Process, put it so graphically, the great tides and currents which engulf the rest of men do not turn in their course and pass the judges by. Judges can be influenced by what is said in the media, but I believe That does not mean a judge should shut himself in an ivory tower. I must tell you, we had the first Chief Justice of the Bombay High Court after the end of the Supreme Court and the establishment of the High Court in 1862, Sir Richard Sauce, who was known as Sauce the Silent. He never read anything, he never met anyone, he never went out. Only in the evening after court hours, he rode on his horse on the beach. That is all his contact with the outside world. To be absolutely free from all influences, Sir Richard Sauce behaved in that manner. But I don't believe that judges should shut themselves up in ivory towers in that fashion. Much later, the Bombay High Court, perhaps in the 20th century, had another judge of the same type, Justice Radhubai Shah, who too did not read newspapers. Judges are not to bend to social pressures or populist ideas, but this does not mean they should not be responsive to contemporary mores and values of the society. They cannot ignore the change in thinking and values. Justice Holmes perceptively observed, we do not realize how large a part of our law is open to reconsideration upon a slight change in the habits of the public mind. Neither judges, nor lawyers, nor any one of us can forget this truth. A judge must recognize he can be influenced and should resolve to counteract it. The test of judicial independence lies in the conscious and conscientious effort to neutralize the effect of personal predilections and overcome personal beliefs, preferences, preconceptions. Of course, this is easier said, but then there should always be sincere and continued efforts in that direction. It is extremely important that judicial independence should not be confused with the proclivity to strike down legislation or executive action in a very cavalier manner. That is not judicial independence, but what you can rightly call judicial showmanship. In the inimitable language of Justice Pai, independence of the judiciary is not genuflection, nor is it opposition to every proposition of government. It is neither judiciary made to opposition measure, nor government pleasure. Of course, only Krishna Iyer could have said it in such inimitable prose. But judges need the great virtue of courage, courage in trying times and circumstances. If judges fail to exercise their much wanted independence, they fail to discharge their judicial oath of dispensing justice without fear of failure. After all, the judiciary is meant for that. Now, when we talk of, I come to certain other nuances of judicial independence, but since the topic includes basic independence as a basic feature of the Constitution, and in another 28 days, we would be observing the Golden Jubilee of the Kesavananda judgment. No doubt, a great judgment that has salvaged something very precious for us. But with utmost respect as students of law, it's very difficult to decipher what is its ratio and whether there is any ratio at all. And whether it has any jurisprudential legs to rest upon. I believe no. I have expatiated this in my talk at the Nani Palkiwala centenary celebrations. Palkiwala, whom I almost revere as a god. The topic of my talk was the basic structure doctrine, its genesis, nuances, and perils. Having said that, the basic structure doctrine, you hear that expression first time in Pakistan in the judgment of Justice Cornelius. It's again mentioned in in Sajjan Singh by Justice Magolkar. Thereafter, you had Professor Dieter Conrad of the Heidelberg University deliver a lecture at the Benares Hindu University. The great constitutional lawyer M.K. Nambiar, the revered father of the former Attorney General Mr. Venugopal, borrowed that lecture from Professor Conrad, and in the passing used it in Golaknath case, but in Golaknath you have no reference to this theory. And then in Kesavananda, Palkiwala built upon it, and with his great powers of advocacy, impressed upon and persuaded the judges, of course by a slender majority of 7-6, or rather 6-6 to be exact, with Justice Khanna casting the dying vote. And we have the doctrine of the basic structure, which means this in one sentence: Article 368 does not enable Parliament to alter the basic structure or framework of the Constitution. Now, Article 368 confers constituent power. When a constitution provides for its amendment, it can be done only in that manner, short of a revolution. Dr. Ambedkar in the Constituent Assembly had said, if the future Parliament wishes to amend a particular article, all that is necessary is to have a 2/3 majority. And those who are dissatisfied with this constitution have always only to obtain a 2/3 majority to amend it. The entire tenor of the Constituent Assembly debates was that all articles of the Constitution were subject to the process of amendment. And this is noted by Justice Khanna in the Kesavananda Bharati judgment. And in the earlier Shakira Prasad case, Justice Patanjali Shastri, speaking for a unanimous constitution bench, declared in ringing tones, to make a law which contravenes the Constitution constitutionally valid is a matter of constitution amendment, and such falls within the exclusive power of Parliament. Yet for the first time in Kesavananda, the court by a slender majority declared that while Parliament has the power to amend every part of the Constitution, including fundamental rights in Part 3, and there were no implied limitations on the amending power, the power did not extend to amending the basic structure of the Constitution, a term not found in the Constitution. No court until then had asserted such a power to annul a constitutional amendment. 6 judges held that the amending power was limited by various inherent and implied limitations. 6 other judges held there were no implied limitations. Justice Khanna, whose judgment ultimately decided the fate of the case, expressly rejected the theory of inherent or implied limitations and held the amending power was plenary, but he held that the word amendment, by its limited connotation, did not permit abrogating the Constitution. But amendment in simple English, plain English, only means change. It is inconceivable how this could be said to be the view of the majority, because it's difficult to call out a majority. In any case, that's now more of an academic exercise. For 50 years. We have accepted, rightly or wrongly. But what comes out from that, the perils of that, I'll come to in a moment. The rationale of all this is that while legislation can be assailed on grounds of lack of legislative competence, violation of fundamental rights, or any other constitutional limitation, how do you attack a constitutional amendment? The ultimate power and responsibility of lawmaking rests in the legislature. But the Indian Parliament not only exercises legislative power, but also constituent power. And the product of that exercise is a constitutional amendment, which is not amenable to any substantive challenge on grounds of that a legislation can be attacked. It is to ensure that by a process of amendment of the Constitution is not denuded of its core or made to suffer a loss of identity that the doctrine was developed. there are problems when we talk of that. And talking of judicial independence itself, the third judge's case, the second judge's case, the third judge's case, and the fourth judge's case, all proceeded on the footing of judicial independence. Article 124(2)(17) vests in the President, which, as you know, in a parliamentary system is nothing but a metaphor for the union government, the power to appoint and transfer judges of the superior judiciary in consultation with the Chief Justice of India. By judicial interpretation, consultation was held to be in concurrence, making the President a consultee. The Supreme Court innovated the apparatus and apparition of the collegium, vesting the power of appointment to itself, quite contrary to the language and intent of the Constitution. That judges should be appointed by and with the concurrence of judges through a collegium, and otherwise it would infringe independence of the judiciary and abrogate the basic structure, I submit, shows the absurd length to which the Constitution can be perverted. Pushed to its logical end, it would even mean that the constitutional process of removal of a judge is encroachment on judicial independence. Sir Radhikrishan Swami Iyer, the greatest constitutional lawyers and constitution makers, perceptively said in the Constituent Assembly, the doctrine of independence of the judiciary is not to be raised to the level of a dogma, so as to enable the judiciary to function as a kind of super legislature or super executive. By its very name, basic structure doctrine is to ensure that the core of the Constitution is not destroyed. And therefore, it logically follows that you have to test it on the basis of what the Constitution provided, not what judges developed by interpretation later. And that is exactly the sin that the Supreme Court committed in the NJAC case. When an amendment is challenged as damaging the basic structure, it would have to be tested with reference to the Constitution as it originally stood, not with reference to the gloss put on it by judicial interpretation. Curiously, unfortunately, this is what was done in the NJAC case. And all in the name of judicial independence as a basic feature of the Constitution. For the court to decide that independence of the judiciary forms part of the basic structure is quite uncontroversial. The court's judgment, however, went further and was based on the assumption that primacy of judiciary in the appointment process is indispensable for independence of judiciary, and by implication forms part of the basic structure. This is a very tall play. There are alternative means of protecting this, and Parliament should have the choice. The Kesavananda doctrine represents a high watermark of judicial innovation, curtailing Parliament's power. It shifts the emphasis of democratic constitutionalism and alters the very foundation on which constituent power is distributed between the judiciary and the amending body. This doctrine, of course, has now come to be accepted as a constitutional aphorism. And I wouldn't, in 2003, argue for undoing it. But the point that needs to be remembered and emphasized is that it's not to be applied in a very cavalier fashion. Anything and everything cannot be put into the basket. Because many times experience has shown us that judges' own notions of what they consider to be basic forms part of the basic structure. That can be a very dangerous thing, and we also speak of the basic structure as if it is something that to prevent the majority from riding roughshod over the minority. It could be also the other way around. If the majority wants a change in the name of this sacrosanct doctrine, you could be prevented. jurisprudentially speaking, the basic, inarticulate, major premise of the Constitution in any democracy, including India, is limited government, as Gurdas Basu very eloquently, elaborately enunciated in his Tech of Law lectures, limited government and judicial review. So the essence of our old system is limited government. And the essence of that limited government and constitutional scheme is checks and balances, which is the most fundamental feature of a democratic constitution. I ask myself, is that basic feature of checks and balances so fundamental in the scheme of things not breached by the basic structure doctrine? Constitutional government abhors absolutism of any kind, but the basic structure doctrine is judicial absolutism or imperialism. Having said that on the question of the independence of the judiciary as a basic feature, let me come back to the practical nuances of judicial independence. Article 141 declares the law laid down by the Supreme Court as the law of the nation, binding on all. Judicial discipline and the regime of 141 require every judge to follow the law laid down by the Supreme Court. That is judicial duty. It's imperative in a hierarchical system of courts. However, nothing prevents a judge at any level, while abiding by the law laid down by the Supreme Court or the High Court, to state in his judgment, of course in very respectful and polite language, if he has any reservations about the view of the superior court and point out what he feels to be erroneous and what may be a more tenable view. That is judicial independence and adherence to the judicial oath. That will give the necessary impetus for review and correction at a future date. Far from being undesirable, it will help in a healthy development of the law, sowing the seeds for future rectification, improvement, or growth. To cite a couple of examples, Broom versus Castle, Lord Denning in the Court of Appeal pointed out the difficulties presented by the House of Lords' decision in Brooks versus Bernard. He doubted the validity of the doctrine propounded by the House of Lords. In appeal, Castle versus Broom, the House of Lords took strong objection to this, but the House did consider the problem. The appeal was dismissed, affirming the view of Lord Denning in the Court of Appeal. To that extent, the cause was served. In India, way back in 1989, you have a case, Niranjan Swain versus State of Orissa, in which Justice Radhacharan Patnaik, then in the Orissa High Court, he later came to the Supreme Court and had a very short tenure of a couple of months because he died in a tragic road accident. He respectfully pointed out the law declared by the Supreme Court in two cases appeared to be flawed. He stated, the rule laid down in these cases is binding on me. However, with respect, I hope the Supreme Court would on an appropriate occasion reconsider these views. That happened more than 28 years later. Of course, without reference to Justice Patnaik's observations. A constitutional bench in 2018 overruled those cases. The cause was served. I'm pointing out this only to emphasize that independence of judicial thought also includes the duty and the necessity to express what one feels to be right, though what is decided is binding. You have to decide according to that. But you put this so that this would accelerate the process of a change. Now, judicial independence cannot be divorced from judicial accountability. Without that, it's all a hoax. Without accountability, independence becomes meaningless and a myth. Moreover, independence and accountability are not ends in themselves. They are means to achieve the goal of fair and impartial administration of justice. Judicial independence is only an instrumental value which no unbridled power. It is not secured by the secrecy of cloistered halls. It cannot be said that increasing transparency would threaten judicial independence. The institution of judiciary cannot be used as a shield to insulate a judge from his actions which have no bearing on his judicial work. A judge must recuse when there is a potential conflict of interest. Independence is not insulation for judges from the rule of law. Again, judicial independence is meaningless without judicial integrity. Integrity in common parlance denotes honesty, straightforwardness, uprightness. But judicial integrity is this and much more. Its essential feature is a passion for justice, informed by a deep and abiding morality. It's the courage of conviction and the willingness to reach the result which the judge's understanding of the law tells him is right, not that which is popular. In fact, judges are trustees of great power. And how trustees should be, even in normal connotations, was so well said by Cardoso before he came to the Supreme Court. He is held to something stricter than the morals of the marketplace, not honesty alone, but the punctilio of an honor, the most sensitive, is the standard of behavior. Then how much more is this trust at once so ennobling and so high? Judges can't forget this. And this brings me to judges taking up office on the heels of their retirement. Being offered and accepting a position immediately on retirement does not augur well for judicial independence. It is destructive of judicial independence. It is destructive of the very notions of a higher judiciary and its values. We have umpteen examples, and they seem to be increasing today. Perceptions do matter, and it is perception that generates public confidence. Arun Jaitley, as leader of the opposition, speaking in the Rajya Sabha, very rightly said that public perception would be that pre-retirement judgments would be influenced by post-retirement benefits. May or may not be, and even assuming that they are not, it is absolutely impermissible, wrong, undoubtedly, for a judge of the highest court to accept an office on the heels of his retirement, be it nomination to the Rajya Sabha or nomination to the Raj Bhavan. There can be no two opinions about that. A judge can, of course, and even other, unfortunately today, both parliamentary legislation and not to lag behind judicial orders, create avenues for post-retirement offices. I don't know why all offices should be only by judges. Let's not elevate judges to any higher level and deify them. Not defy them, please don't, but don't deify them. Remember that judges are as earthly, men of straw with feet of clay as any one of us. Nothing more, nothing less. They are entitled to, I wouldn't even say respect, they are entitled that their orders must be absolutely implicitly obeyed, because that's the rule of law. Respect is what each one has to command for himself, not to demand it. And that comes from within. The moment you see someone who is worthy of respect, you bow down. And that can be to anyone. It is to the human personality, not to the office you hold. The Constitution, you can, after a cooling off period, contest and get elected. By all means, as a citizen, you are entitled. But not take that within a couple of weeks of your retirement. The Constitution envisages nomination to the upper house of persons having special knowledge, practical experience in matters such as literature, science, art, social science. The nomination is done by the President, of course, it was said, of course by the President, but the President acts on the aid and advice of the Cabinet, he cannot act otherwise. And therefore it's by the Union Government. It is difficult to envisage in what matters set down in Article 80 a retired Supreme Court judge fits and fulfills the criteria. So also governors, again appointed by the President on the aid and advice of the Cabinet. What special qualifications a retired Supreme Court judge has to fill a gubernatorial post passes one's comprehension. Such appointments are not happening for the first time. In fact, it happened way back in 1952, before most of us were born. Perhaps even before you were born, Professor. Justice Fazl Ali, the senior most puny judge of the Federal Court and the Supreme Court, was appointed as Governor of Orissa and Assam in 1952. Chief Justice Chagla, whom we all revere, resigned at the call of the Prime Minister to be appointed India's ambassador to the United States, then High Commissioner to Britain, and then, of course, member of the Union Parliament. But I would submit these are exceptions, and exceptions prove the rule. Two wrongs don't make one right, and even more, everyone is not a Chagla. One does not become a Shakespeare by marrying a lady older than oneself. So judges who have followed later cannot claim to be Chaglas. Far from that. Chief Justice Subara, one of our very distinguished, adorable judges, who, to use the elegant phrase of Lord Diplock, altered the habit of the minds of judges. While still holding the highest judicial office, met and discussed with the opposition parties his candidature for the post of the President, resigned before his time was up, and contested the presidential election. Of course, rightly, it did not win approval, but incurred public criticism as being an act of grave judicial impropriety. It's quite a different matter that years later, Chief Justice Hidayatullah, many years after his retirement, became Vice President, and it was a unanimous choice of all political parties. Again thereafter, you had Justice Khanna and Justice Krishna. Justice Khanna holding the office of the Union Law Minister for a day or so, and then contesting the presidential election in 1982, and Justice Krishna in 1987. But all of that was many years after they demitted office as Supreme Court judge. Of course, after you demit office and after a polling period, as citizens you have the right. But that is very different from things happening in 4 weeks, 6 weeks, and all that. And what is the test? It is what Lord Denning famously said in a different context. Bias of a judge and interference in appeal with the award of compensation in accidents claim. Lord Denning said, the test is this: right-thinking people would leave the court thinking the judge was biased. Or, if in a compensation you've seen the amount, oh, is the immediate expression. It's too high, but it's too low. And this is the kind of impression and this is the kind of response that situations like this would generate in ordinary right-thinking people of India. And that test you would fail. Because judges, like Caesar's wife, should be above board. Accepting such appointments and nominations, he values the high office. Well, there are shortages of many commodities. As Palkiwala told us, nothing is as scarce as intellectual integrity. It has been well and rightly said that when the Constitution confers on judges enormous power and responsibility to ensure that all institutions and citizens conform to law and standards of propriety, it is logical to expect that judges themselves, both in office and out of office, and also post-retirement, maintain the highest levels of probity. They should not only be, but should be seen and believed to be exemplars. This tradition is and has to be unbending and inveterate. Now I'll give you a couple of examples. I hope I have a little time. Independence again does not depend on the source of your appointment. Please take two great examples. Earl Warren in the United States, Sudish Pai in India. Earl Warren, as you know, was President Eisenhower's personal nominee. He was the governor of California when he was appointed Chief Justice, and you had the famous Brown versus Board of Education case. After the judgment was reserved, there was a dinner at the White House in February 1954. Over coffee, Eisenhower took Warren by the arm and asked him to consider the perspective of white parents in Deep South. These are not bad people, the president said. All they are concerned about is to see that their sweet little girls are not required to sit in school alongside some big bad bucks. The Chief Justice just ignored it. May 1954 came the unanimous judgment in Brown versus Board of Education authored by the Chief Justice himself. So this is judicial independence. And to tell you a story, in 1960 when President Eisenhower debuted office, he was asked by the press as to what was his greatest achievement or contribution as the president. He said it's difficult to answer that, but I can tell you what was my worst decision. And the worst decision, he said, was nominating Earl Warren as the Chief Justice of the United States. That is a different matter. Justice Krishna Iyer, we all know, was a member of the legislature. He was the first, he was a minister holding so many portfolios and the first ever elected communist government under the sun. He held the portfolios of home, law, electricity, public works, whatnot. And then he came to the Supreme Court via the Law Commission in 1973. And it is again well known that he came there at the instance of his good friends in the Communist Party or the leftist leadings, Mohan Kumar Mangalam, H.R. Gokhale, Shri Ray, all that is well. But in 1975, when Mrs. Indira Gandhi, the Prime Minister, lost her election case in the Allahabad High Court, H.R. Gokhale, Law Minister, telephoned Krishna Iyer, his close personal friend, who was then the vacation there, and said, I want to meet you. Krishna Iyer said, yes, but for what? He said, you know, the Prime Minister has lost her election. He said, fine, I've also read it in the papers. So the Prime Minister has lost her election case. I'm sure the Prime Minister has her advocates. So she has to file an appeal in the registry. The registry will list it before the court, and that's the end of the matter. You don't have to meet me, and you can't meet me. So this is independence. I'll give you a few more stellar examples which may shock you in this year of grace, 2023. The kind of judges we had, they were godlike. Haribhushan Chakravarti was the first Indian Chief Justice of the Calcutta High Court. Who could tell a Chief Justice of India, Justice Maharaj? The Chief Justice had come to the High Court after the court began its sitting. And when the registrar came and whispered to Chakravarti that Chief Justice has come, he said to the hearing of the entire court, why are they loitering in this building when we are sitting? Please ask them to leave and come after the court rises for the day. These are High Court Chief Justices, not those who are bending. This is judicial independence. And it must be said to the credit of Chief Justice Mahajan, they didn't take it amiss. They left the court and came in the evening after the court hours. Chief Justice Shankar Prasad Mitra, I have heard it from his own mouth, told Chief Justice A.N. Ray, the tradition in the Calcutta High Court is that anyone who visits the High Court will be received by the Chief Justice of the High Court when he enters his chamber, that's all. It seems A.N. Ray, who superseded 3 judges and came to Calcutta, there was a grand welcome when he came by Rajdhani. Chief Minister Siddhartha Shankar Ray was also at the Howrah station to receive him. Of course, the Chief Justice received him inside his chamber. And Ajit Nath Ray seems to have taken it a little hurt by that. And Shankar Prasad Mitra told me that he wrote to him, "Dear Brother Ray, coming as you do from our High Court and knowing our traditions well, you may be rest assured that as long as I happen to be Chief Justice, you will be received only after you step into my chamber." This is on record. Letter written by the Chief Justice of Calcutta to the Chief Justice of India. Chief Justice Kantawala, when he was Bombay, Chief Justice of Bombay told Chief Justice Chandrachud, Father Chandrachud, when he wanted some names for the High Court judges, "Chief Justice, please don't waste your time. As long as I am Chief Justice here, these names will not go." And in Bangalore in 1975, when Justice Ray came as Chief Justice of India, he wanted to sit with the judges in court. As you know, the Supreme Court has no supervisory jurisdiction of the High Courts. Though of course today many things are done. And therefore Supreme Court judges cannot sit on the dais of the High Court judges unless they are invited. They can sit as guests. So the judges here refused, saying, "No, we invite you only for a dinner, not to sit with us." Chief Justice Ray said, no, you see, I have to make appointments to the Supreme Court. So it would be good for me to see. And you must know what was the response of our judges. Justice D.M. Chandrasekhar, the senior most judge, told him, "In that case, Mr. Chief Justice, please take it. We are not interested in your Supreme Court judgeship. You may go, but you will not sit with us." All this happened in our own lifetime. I am not talking stories of the Bharati and the Ramayana, but to what levels that we've fallen now in a quarter of a century or half a century. Unbelievable. Same is the problem with additional judges. Talking of judicial independence. Additional judges are like as if, and they behave that way also, as if they are on probation. 1966, at the centenary of the Allahabad High Court, Chief Justice Subbarao had very rightly said that appointment of additional judges detracts from the concept of judicial independence. Additional judges are only when there is a quantum jump in work to accommodate that. Otherwise, you must always have permanent judges. But today, the practice is additional judges, as if they are on probation, and believe me, they behave as such. And not satisfied with that, the Supreme Court on the administrative side has even a mechanism of verifying, testing, examining their judgments. And there is also another practice that before you are appointed, you are called for something like an interview, never called an interview. The thing is, those who are to be watchdogs conduct themselves as police, to use Palkiwala's famous expression. And then what judicial independence are you talking about? One more disturbing sign. To be a judge of the superior judiciary in the common law tradition is considered an invitation to cross over from the bar to the bench. Today, unfortunately, we have judges in their welcome, thanking everyone under the stars, thanking the Chief Justice, thanking the collegium. I thought it should be the other way around. Those who appoint you should thank you for accepting the judgeship. Chief Justice M.S. Menon, way back in the 1960s, considered it one of his greatest achievements in his judicial life, that he was able to persuade V.R. Krishna Iyer to come to the bench. So this is the tradition. That's the question of thanking anyone. You belittle yourselves and make us feel ashamed. And that brings me to what Sripadagalvaru had set up as a beautiful practice in the Supreme Court. In the Supreme Court, to begin with, there were no farewells, there were no welcomes, only obituary references. In fact, in one of the first retirements, when Sripadagalvaru as Attorney General was sent for by the judges to say, so and so is retiring, he said, no, I will not say anything, I will speak when you die. Only obituary references. Because at farewells and welcomes, everything except the truth is said. And that is the only truth. We hear it day in and day out. Now you have Supreme Court adhered to that practice for a long time. It is given up today. You have farewell and welcome in the court, outside the court, and everyone from top to bottom makes speeches which reflects anything but the truth. And we talk of judicial independence. In fact, even for a retiring judge, there was only a non-speaking farewell on the lawns of the Supreme Court earlier. Only 2 exceptions were made. And all this was, of course, in the last century. This century, everything has changed. Justice Matthew and Justice Shri. And commenting on it, Chief Justice Yashwant Chandrachud said, in a foreword to, you have the beautiful book, A.K. Matthews' Lectures and Speeches, 1976, published by Eastern Book Company. In the foreword, Chief Justice Chandrachud said, it is not for nothing that the Supreme Court bar very consciously decided to give Justice Matthew a speaking fact. He deserved it. And for Justice Pai, again there was an address which was prepared by Dr. M. Singhi, Mr. Feliverima, and Daniel Latifi, which was read out when he retired on the 15th of November 1980. These were exceptions. But today, you have anything and anything. And it is also this. Someone very nicely said, everyone looks to the north. That's Delhi. That's the Supreme Court. And therefore, judges always have their eye on that. Earlier, you know, some of the greatest judges refused to go to the Supreme Court. The first 3 Indian Chief Justices of the 3 chartered courts, Justice Pradibhushan Chakravarti in Calcutta, Justice Chagla in Bombay, and Justice Rajamanna in Madras, refused to go to the Supreme Court. Today, of course, there's a beeline to go there. Nothing wrong in going there, but believe me, I have said this to judges themselves. Hardly anyone goes there to make any contribution to the law. Let us be very clear about this. They go there because you have an extension of service of 3 years and the perks that go with Newton's daily. Raise the age, make both the retirement ages the same, I think that rush would come down. I'm not, pardon me, don't mistake me, I'm not a cynic. I'm not trying to criticize, but then these are all various dimensions of judicial independence. And unless we have that, and unless we know this, all our talk is bunk. Earlier, if a Supreme Court judge came to your city, not we as outsiders, I'm talking of High Court judges, no one knew. What's the situation today? They run after them. And I have also known, I can give names, it's not right to mention names. Those people sitting there expect you to do that. So you are appointed because you know, you are appointed because you serve. Earlier you were appointed because you were known through your judgments. If you read Justice Gajendra Gadkar's memoirs, there is a beautiful incident there. Justice Bachawat, Ranveer Singh Bachawat, came from the Calcutta High Court, a very eminent judge. And he was to be sworn in the next day as the judge of the Supreme Court. So he made a courtesy call. He walked to the Chief Justice's house. Of course, those days you didn't have this kind of security problems. Just to call on the Chief Justice. So he entered the gate and said, "Is the Chief Justice in? Would I be able to meet him?" There was a person sitting there on the lawns. And he said, "Who are you?" "I am Bachar." And that was the Chief Justice himself sitting there. That was Virendra Gadkar sitting there. He said, "Oh, come. So you're the person to whom I must administer the laws tomorrow." The point I'm emphasizing is, they did not even recognize each other. Bachawat didn't know that he was talking to Virendra Gadkar, and Virendra Gadkar didn't know it was Bachawat who had walked in. Bachawat was known through his judgments when the appointment was made. This is Supreme Court, this is High Court. All that is what I am trying to emphasize. Today the collegium has spoiled all this. Apart from whether it is constitutionally and jurisprudentially correct, we know what's happening. And everyone behaves and allows himself to be treated in this fashion. The behavior of judges off the bench at all levels is an important feature that is perturbing and detrimental to the integrity and dignity of the system. It's pathetic to see how members of the lower judiciary genuflect before High Court judges and how they are treated lightly. Of course, not all, I'm not universalizing. But even one rotten apple is bad enough. It is equally saddening to see the very subservient behavior of High Court judges before Supreme Court judges. They call them their Rothschild. But High Court judges should call Supreme Court judges by their name if they are close friends, or at least judge. To hear a High Court judge addressing a Supreme Court judge as your Lordship, I have told judges themselves that we feel ashamed, nothing less. This also brings me to the final point about critical legal literature, which is something which we have to develop in India. It's hardly there. Such criticism is not only to be tolerated, but must be appreciated. Tolerance, said Dr. Radhakrishnan, is the homage that the finite mind pays to the inexhaustibility of the infinite. What a beautiful expression. Dr. Radhakrishnan said, tolerance is the homage that the finite mind pays to the inexhaustibility of the infinite. So, criticism is not only to be tolerated, but to be appreciated. And I will end by referring to Glanville Williams, as you know, great professor. Stringent criticism of the decision of the House of Lords in Anderton was in Ryan in 1985 in 8 cases. And the law lords response to it. Look at the criticism. The tale I have to tell is unflattering of the higher judiciary. It's an account of how judges invented a rule based upon conceptual misunderstanding, of their determination to use the English language so strangely that what they spoke by normal criteria would be termed untruths, of their invincible ignorance of the mess they made of the law, of their immobility of the subject, carried to the extent of subverting an act of parliament designed to put them straight. This was the criticism in the Cambridge Law Journal in 1986. The title of the article, The Law Lords and the Impossible Attempts. Lord Aylsham, Lord Chancellor, presiding in the next case, R versus Shivpuri in 1987, said, there is obviously much to be said for the view expressed by Lord Bridge, gave the leading judgment, said to be expressed by Lord Bridge, that if a serious error embodied in a decision of the House has distorted the law, the sooner it is corrected, the better. And Lord Bridge, giving the leading opinion for a unanimous House, overruling the earlier decision which was criticized, said, this is actually intellectual honesty. This is greatness. I cannot conclude this opinion without disclosing that I have had the advantage since the conclusion of the arguments in this appeal of reading the article by Professor Glanville Williams. The language in which he criticizes our decision in Anderton versus Ryan is not conspicuous for its moderation, but it would be foolish on that account not to recognize the force of the criticism and churlish not to acknowledge the assistance I have derived from it. So this is intellectual honesty, integrity, independence that we expect of judges so that our freedoms are safe in their hands. Thank you very much.
Thank you, sir, for insightful words. Moving on to the question answer round. If anyone has any questions.
Good morning, sir. Yeah, so you mentioned that there is Article 141 in our Constitution which says that any law which is put forth by the Supreme Court should be bounding on all the other high courts.
On everyone, not only the high courts.
Within the territory. So after hearing your speech, when there's no basic consensus among the judges of the High Court or the Supreme Court, do you think this law should still be there? Don't you think it should be amended?
Sorry, I didn't get your question.
So you got the article part, right?
Yeah, Article 141 law binding, fine.
Yeah. So after your speech, what I inferred is that there's not even like basic consensus among the judges of both the High Courts and the Supreme Courts. Like
About what?
They have a lot of conflicts within each other.
No, that may not be, that's not what I conveyed or wished to convey. Of course, conflicts would always be there because, as is very rightly said, you can't expect unanimity between two right-thinking, rational people on everything.
So, but don't you think it will be biased because of this? Don't you think it will be biased?
What would be biased?
The judgments.
Every judgment is biased because it is through a human agency. Not bias in the sense in which we use in administrative law, not suffering from the vice of bias. But to say that a judgment is not biased would be the whole untruth. And that is exactly what I said. Justice Patanjali Shastri pointed out way back in 1952 in V.G. Rao's case. And that's what, if you read the nature of the judicial process by Cardoso, you will find to some extent all our background, our ideas, our thinking would influence the question is, ultimately it's a question of balancing. As Aaron Bharati, the former president of the Shri Supreme Court, his beautiful book, Judge in a Constitutional Democracy, says that the ultimate task is balancing. You have to eschew all these likes, dislikes, but it will never be totally absent because you are human, I am human, we are all human. And then you otherwise will have machines. And machines will never give you anything. That is what mine.
Thank you.
Sir, I have two questions. Firstly, the statute on appointment of judges says that the executive must appoint the judges in concurrence or consultation with the Chief Justice. So firstly, that says that the executive must have some say in who the judges on the Supreme Court or the High Courts are. That is a bad system in my opinion, because we've seen through the first judge's case and what followed that the government will obviously appoint judges who will favor their side of the story. Coming to the other aspect, that is what you mentioned, judicial primacy was a tall claim in saying that the judges only must appoint themselves. So considering that both are two ends of the spectrum, how do you arrive at a situation where the appointment of judges is right? And secondly, the second question is, you said that the basic structure doctrine itself was judicial imperialism. However, the NJAC was struck down based on that understanding. If we didn't have that, and the NJAC, instead of two eminent persons, suggested that they should have two more persons related to the executive there, that would have meant that again the executive would have primacy in appointments. So why would you say that that is a good, the basic structure doctrine is a bad thing? So these are my two questions.
Yes, thank you for your very interesting question. There's a Greek philosopher, I forget the name, whether it was Aristotle or Plato, who said, to seek to be wiser than the law is exactly what by good law is forbidden. The constitution makers in their wisdom and with their rich experience had put down in the constitution the mode of appointment. The question of concurrence of the Chief Justice was debated in the Constituent Assembly. And Dr. Ambedkar very emphatically repudiated it, saying, when we are not prepared to vest it in one person, the President, it would be totally impermissible to vest it in the Chief Justice, however eminent he may be. Nowhere under the sun do judges appoint themselves. It is only the executive that does all the appointments. Who pays the judges' salaries? Who gives them their houses? Who gives them their benefits? To whom do they turn for all this? It has to be the executive. That does not mean that there is executive pressure. Of course, ultimately, it all depends on who mans what position. Prime Minister Asquith very beautifully said, it depends upon the holder of the office what he chooses to make of it. And associating the executive with the appointments can never be said to be impermissible. There may be an amount of bias. Now, are you telling me that there is no bias in the collegium system? Let me tell you emphatically that only that exists. It is I scratch your back, you scratch mine. The collegium system is far, far, far more biased than the executive can ever dream to be. Justice Krishna Iyer, with his wide experience in all the three fields, very rightly said, it is now only changing your prostrations from the white-robed politician to the black-robed brethren. Nothing less, nothing more. And to say that if it is with the judiciary that there is no bias is the greatest untruth. All sorts of considerations keep creeping. At least the politician faces the electorate every 5 years. Good, bad or ugly. Their lordships, only time can take them away. Either at the end of their tenure or God calling them away to heaven or hell. Basic structure doctrine has salvaged a lot. There's not the slightest doubt about that. But then, as students of law, what is the basis for that? And you're stifling democracy. That our democracy may not be working well is another issue altogether. We are discussing a principle. We have to reform. I am not for one moment saying that all is well, far from well. Neither is all well with the other side. Let's not forget that. Nothing is well anywhere. But that doesn't mean we despair. There has to be concerted, conscientious, continuous efforts to improve. No doubt about that. And NJAC, what did the NJAC do? Article 124, in fact, NJAC is more, I think everyone was clouded. There's not the slightest doubt about that. The 99th Amendment and the consequential NJAC is more loaded towards the judiciary than the original 124. And I can't understand how it was biased in favor of the executive. You had the Chief Justice and 2 senior most judges, 3, the Law Minister 4, and 2 eminent, nominees. And they were to be appointed by the Prime Minister, the Leader of the Opposition, and the Chief Justice. What is wrong with that? Today the Supreme Court says you appoint election commissioner by that. It's not by a law, it's by a judicial fiat. This was by a law, almost unanimously passed by Parliament and ratified by the greatest number of assemblies. The argument was, how could these 2 people, nominees, or even 3 override? Why can it not be that one of the judges will also join with the executive? These are various permutations and combinations. Do you mean to say by definition a judge is not political? Many of them are politicians would stand in a higher pedestal than many of them in playing politics. Not political science, I say playing politics. A politician would win for good reasons. A politician standard would be far higher. So they may also join. And as Chief Justice Chandrachud said very beautifully in Indira Gandhi versus Rajda, the fear of perversion is not the test of power. And I really don't understand, forgetting all this rhetoric, how the 3 in the judiciary could be overruled. And there may be good reason also. See, this judicial privacy in the matter of appointments is something that passes my comprehension. Why should it be? I would go to the extent of saying that if judicial involvement in the process was 0, even then it would not be unconstitutional. Where are judges associated in the United States? The Senate Judicial Committee nominates a political process. But that doesn't make them non-independent. I gave you the example of Earl Bond. Of course, there may be people both ways. That always happens whichever the system of appointment. Whether the executive appoints them, whether the judiciary appoints them, whether they are elected, whether they are nominated in any office. Ultimately, as was said by both Dr. Rajendra Prasad and Dr. Ambedkar in the Constituent Assembly on the eve of the adoption of the Constitution, however good a system may be, it ultimately depends upon the people who work it. And therefore, whatever be the process of appointments of judges, it is people who have to make those appointments that matter.
With that, we come to the end of the talk, which is delivered by our eminent jurist, Professor Sudish Pai. See, the entire talk is given for the purpose of knowledge, and it is not for disseminating something else. How the institution should function, how ought to have it should have functioned, and how it is actually functioning. So that is why he gave the 3 illustrations from the prevailing practice that has taken place and that is taking shape in the country. So one should be objective. As students, we should be more objective. I still remember, I saw on the TV, when Arun Jaitley was the law minister, he was making a statement In a function, there were several people who came and shook his hands. At that time, two or three of them, during this process of shaking hands, they gave their cards, business cards. And having gone out after the function, he started looking at them, and it is from the judiciary, High Court judges. High Court judges is openly came, it's not, the truth is a defense information, not a fibble. So, this is how they try to influence the law minister even at every level. And this should not happen, because this is much against the principles and ethics, and much against what is being discussed in the Constituent Assembly. So it was one of the master class lectures which we have heard in this semester. Sir, I am really honored to have you here, and on behalf of the students,
Let me just clarify for one moment.
As Dr. Subramania said, all this talk is not to criticize or condemn. It's only an endeavor to seek improvement. Because we are all stakeholders. The judiciary is not the property of the judges. The judiciary is the property of India and the people. And in saying all that I have said, let me quote one of the greatest of minds. I am fortified by what Justice Holmes said. I take it for granted no hearer of mine will misinterpret what I have to say as the language of cynicism. I trust no one will understand me to be speaking with disrespect of the law because I criticize it so freely. I venerate the law and our system of law as one of the vastest products of the human mind. But one may criticize even what one reveres. Law is the business to which my life is devoted, and I should show less than devotion if I did not do what in me lies to improve it. And he spoke of the secret isolated joy of the thinker who knows that 100 years after he is dead and forgotten, men who have never heard even his name will be moving to the measure of his thought. Friends, it is in this spirit of inquiry and humility that I have placed my thoughts before you.
Thank you so much, sir. Now I would like to invite S. Srilata Patro, 4th semester DLLB Honours, to deliver the vote of thanks.
J.T. Chesterton quoted, "Thanks is the biggest form of thought, and that gratitude is happiness doubled by wonder." Good afternoon, everyone. I deem it a great honor and privilege to propose the vote of thanks on this insightful session. First and foremost, I would like to extend my gratitude and warm greetings to our beloved guest, V. Sudish Pai sir, for such an exciting and engaging session. Through you, we got to know today the basic structure doctrine, the judicial independence, and the various judgments which had a landmark impact on the Constitution of India. Through you, we learned that the least and the shocking exemplary examples that the judicial independence today have. Again, I would like to thank our beloved Dean, Professor Dr. T.R. Subramania, for his constant support in for organizing such various insightful guest lectures. I would also like to thank our director, Professor Dr. V.J. Pranishwaran, for giving us the opportunity to conduct this event. I would also like to thank our beloved faculty coordinator, Dr. Vandana Rajput ma'am, for this guest lecture. And last and foremost, I would also like to extend my gratitude to the faculties and my dear friends. Thank you, everyone. I wish you a good day ahead.